SJC-11928, Commonwealth v. Oswald, Millien.
If it please the court, Mr. Chief Justice, I'm still David Hirsch, this time representing Mr. Millien. This case is a little bit different from the last one. The major issue here is whether there was prejudice from what the judge has already found to have been ineffective representation by the counsel. The judge, however, found that there was trial evidence that the girl in this case, Johanna, was not only shaken but suffered some sort of impact injury as well. That's not true. There was no such evidence. The judge found that due to the powerful medical evidence that was before the jury, it is unlikely that an expert's assistance or opinion would have accomplished something material for the defense. That's legally and factually wrong.
It's not true that there was evidence of left side of the brain physical injury?
Oh, there certainly was, but Dr. Newton distinguished between the two kinds of injuries. She said that the fall that caused the left parietal injury did not cause the traumatic brain injuries. Specifically, that it did not. She differentiated between the two.
Don't you make an argument also that she changed her testimony between motion for new trial and trial?
Yes, then at the motion for new trial, she said, oh, I never said it was just shaking. I said it was impact and shaking that caused those injuries, which is the clear contradiction of her earlier testimony, and that was the third way in which the hearing judge erred, by saying that there was no major inconsistency between her testimony at trial and at hearing.
Help me a little bit. I'm a little bit confused with regard to the issue of the skull fracture and the fracture of the thoracic vertebrae 11 and 12. I gather the fracture of the thoracic vertebrae 11 and 12 cannot be dated.
Correct.
Can the skull fracture be dated based on the level of healing? I know with regard to the tibia and such, the view was that they were in advanced stages of healing and therefore had occurred well before the incident.
To the best of my recollection, there was no testimony about that one way or the other. The testimony from Dr. Yushinsky is that the damage to the right, the fracture on the parietal part of the brain does not preclude in any way the likelihood that the child fell on the back of her head, because of the tendency of these thin parts of the skull to move in and out, to be bent and essentially broken by the intracranial fluid caused by the fall on the back. One of the biggest issues in this case is something that Justice Cordy questioned me about in the last case, or perhaps it was Justice Spina, whether the judge has the right to determine, has the power to determine, well, I believe this expert more than that expert. Well, that's certainly what the judge did here, and it's way beyond the power of that judge or any judge. We have the judge saying, taking Dr. Newton's side, for instance, when she said, well, all those biomechanical studies that Dr. Yushinsky cited, they've all been refuted. That was the entirety of her testimony on that issue, and the hearing judge held they had been refuted. That's not her job. In terms of the claim of overwhelming
I'm sorry, before you leave that point, what do you say is the appropriate standard? Does it mean that whenever somebody's ineffective for not offering testimony, the judge has to view it in the light most favorable to the defendant? Is that what you're saying?
When the defense presents countering evidence at the motion for new trial, evidence challenging the evidence behind the conviction. At that point, there is, the judge has no power to determine, I prefer this one to that one. That's the holding of Roberio, that's the holding of Hampton.
Okay, but try my question.
I thought I had answered your question.
Must it be viewed in the light most favorable to the defendant?
Where there is conflicting evidence offered, the judge, yes, must view that evidence in the light most favorable to the defendant. That's also the Cohen case and others. So,
So by that standard, if a defendant is ineffective, if defense counsel does not advise his client about the need to testify, and defendant later says, golly, I would have testified and said I didn't do it, then defendant always wins because you must view it in the light most favorable to the defendant?
no, that's a very different situation because the courts have generally held that with recantations, the self-interest of the defendant is kept in mind. The failure to mention something beforehand is kept in mind. It's a very different situation from two different theories. And our courts have recognized that in many different contexts. When it's an expert saying, I disagree with what has been said before, it's not X, it's Y, that's not the same as that kind of self-serving recantation or any new factual evidence that would be presented, say, a new witness saying, oh yeah, I saw it happened and it was this way rather than that way. In that situation, it is not a matter of the court having to remain neutral about the facts. In this situation, in an expert situation, it is.
Counsel, would you agree that what happens on a motion for new trial is a little different from the gatekeeper function? We're not talking about whether the evidence is sufficiently reliable to get to a jury, the kind of Dalbert-Lanigan kind of test. Here, it's part of the ineffective assistance calculus for the judge to ask whether or not the evidence would have made a difference in the outcome. So there has to be some kind of weighing there on the credibility of the offering.
That weighing has been done, but in a different way. In many cases, the courts have said, yeah, there was an expert at the motions hearing who put forward a theory, but say, in many of the cases, the courts have said, it wouldn't have made a difference. Even if everything this new expert said was true, it did not exonerate the defendant. It did not even potentially exonerate the defendant.
Isn't that what the judge said here?
No. What the judge said here is, I don't believe it. There is no evidence here that the judge said.
Well, the logic, I mean, just reading her opinion, it's a little bit more than I don't believe it. I think she went into some detail about why it wouldn't have made a difference in this case, because the expert opinion did not address the broader allegations about how this child became injured.
And I think there we have to look into what was an abuse of discretion by the judge in making those findings, because for one thing, she seems to have relied on the amount of evidence. It didn't matter what the defense put up there because the evidence was so strong on behalf by the Commonwealth's experts, and that didn't go to whether she believed whether Dr. Yushinsky's testimony was good or bad. That just went to amount that basically said, well, one side is so convincing that there's nothing the other side can do about it, and that is not the law. Judges advise juries all the time the number of witnesses doesn't matter, and I think that's the mistake that the judge was making here.
I thought she was pointing out a gap, a very important gap in the proffer that the defendant made that it would have left unrebutted some part of the Commonwealth's case.
That, again, is where we believe there is an abuse of discretion, because those parts that were unrebutted weren't a part of the case. As Dr. Ushinsky repeatedly said in his testimony, it doesn't really matter about the other injuries. The other injuries are separate from this. What we need to find out is whether shaking caused this particular injury. We don't need to look at the tibia injury, the rib injuries. They're from earlier, and they just have no effect on what is the issue here, whether the shaking caused these particular injuries.
What about the thoracic vertebrae?
The problem with the thoracic vertebrae evidence is we don't know when it was inflicted. We don't know if Mr. Millien was there. Excuse me. We just do not have enough evidence to tie it to this incident, to tie it to him. So I think Dr. Ushinsky made a very strong case for why the other incidents didn't matter. And I would again state that the trial judge erred by, in this case, finding reasons to disbelieve him when it wasn't her job to do so. If he was right.
What do you say at the end of her opinion, I think, she talks about, well, I'm not even sure he would be qualified under Dalbert Lanigan. What do we do with that?
I think we again, well, first of all, she didn't rule on it. Had she ruled that he was not qualified, there too there would have been an abuse of discretion. This is an expert who has testified, I think he said half the states in the country.
But this isn't his pediatric...
We can do that with every expert who has testified in either of the two cases. One isn't an ophthalmologist, one isn't a radiologist, one isn't a neurosurgeon. Law is clear that that a medical expert need not be in a particular specialty for his or her testimony to be admissible, to be valid. In fact, I think the judge's argument here would preclude anybody but a so-called child abuse expert to testify. But then we look at a child abuse expert. They have a certain amount of knowledge in various fields, but it doesn't mean they are histologists or any of these other things we're talking about. I can't even remember the names of the specialties, but there are, I'd like to go to one of the points raised in my brief. That's about Commonwealth versus Strickland, where there was an expert testimony, and I think this answers some of Justice Hines' questions. There was an expert witness who was his or her theory was contradicted by eyewitnesses at the scene. In other words, the eyewitnesses said, no, couldn't have happened the way he did. We were there. It wasn't like that. He could only say, and this was the biggest part, the expert could only say that a certain medical disorder, a mental disorder existed, this Munchausen's by proxy, provided absolutely no evidence that the chief witness, the wife in this case, suffered from Munchausen's. It was just, well, it's out there. Here we have the testimony of Dr. Ushinsky, far different from that the injuries could not have occurred as the Commonwealth said, and were likely to have occurred as Mr. Millien said. And this was a response to the Commonwealth's argument, the Commonwealth's testimony that it couldn't have happened as abuse. He rejected that. That's a long stretch from those cases in which there's just a possibility, well, yes, something might have happened. Here, it couldn't have happened. And that's one of the big differences. Other than that...
Now, was there evidence here as to what the floor was in the living room?
I don't believe there was. My sister may know that better than I do. I'm not sure at all about that.
So we don't know whether there was a rug?
I don't think we know about that. There was lots of testimony about falling to a hard surface, so I think there was an implication that that's what it was, but I'm not sure. The challenges to Dr. Yushinsky's testimony, I see my time is up, and without any, if there are no further questions, I will sit down.
All right, thank you.
Thank you.
Good morning. May it please the Court, Kate Simony, Assistant District Attorney, appearing on behalf of the Commonwealth. First of all, I'd just like to respond briefly to the contention that the testimony at trial was that the injuries were caused by shaking alone. The trial record, as was correctly found by Judge Haggerty at the motion for new trial, clearly establishes that not only the medical expert testimony, but the treating physician's testimony established that there was, in fact, in this case, a forceful high impact with a hard surface to the infant's head. And I believe the exact words used by Dr. Newton at trial was, there's a skull fracture, so clearly there was a blow.
And could that have occurred by falling off the couch?
The testimony was that a skull fracture could possibly or conceivably be sustained by a 17.5-inch fall from a couch, but that it was incredibly unlikely. But that the combination or constellation of all of the head injuries suffered by the infant in this case could not have been. And that's what the gap in the proffered defense expert testimony was with that of the Commonwealth's witnesses.
So, but the constellation of injuries then would have had to have been related to the shaking,
Well,
not to the skull fracture.
the mechanism that was described by the Commonwealth witnesses at trial was that there was shaking, but that there was also an impact.
I understand that, but what's the impact of the impact on those constellation of injuries that you're talking about, the traumatic brain injuries?
Well, in this case, there was a skull fracture, which established that there was
So
clearly
the
the
skull
impact.
fracture, I guess what I'm trying to get at, I'm sorry if I'm not making myself clear, if there's a skull fracture, and the skull fracture was possibly caused by a fall from the sofa, and if all of the traumatic brain injuries could have resulted from the skull fracture, that's the question I'm getting at. You're saying it couldn't have, and I want to know really the rest. You're basically saying that the constellation of injuries could not have happened from the skull fracture. The constellation of injuries happened as a result of shaking.
The other injuries did not occur as a result of the skull fracture. They are somewhat distinct.
You're talking about just the brain injuries, right?
Yes, the head injuries, Your Honor.
Okay.
The dispute in this case, the dispute that, what Dr. Uzinski testified to, he didn't say that there could not have been shaking. His position was that shaking alone cannot create the kind of acceleration, deceleration forces to cause this type of injury to an infant's head without there also being an impact with either a hard or a soft surface.
So are you saying, basically, if I'm hearing you correctly, that what Dr. Yushinsky testified to was in substance the same as what Dr. Newton testified to at trial?
Well, no. Well, he said that there must have been an impact. Whether or not there was shaking was beside the point, that in any event, in this case, there was an impact, that shaking alone could not cause the infant's injuries. What was presented by not just Dr. Newton, but all of the Commonwealth's witnesses, was that there were shaking forces, but also an impact, which is not inconsistent. What Dr. Uzinski said is there has to be an impact to cause these injuries. Everybody agreed that in this case, there was an impact.
But maybe I'm wrong. I take it Dr. Newton said but this particular triad of injuries was essentially conclusively caused by shaking.
Well, in this case, this isn't actually an easily defined shaking case because there was an impact. Yep. That no one was discounting the mechanism of shaking with respect to these injuries, particularly with regard to the retinal hemorrhages. It's the shearing forces caused by the vigorous back and forth motion involved in shaking that cause the type of shearing forces that create the retinal hemorrhages that were found in this case. I think what everybody agrees is that an impact combined with the shaking increases the amount of force on the infant's head.
But did Dr. Uzinski testify that these injuries could not have been the result of shaking?
He testified that they were
Were
not the,
or were not the result of shaking.
his testimony was that they could not have been shaking alone without an impact. And that opinion, quite simply, was not relevant to this case because everybody in this case agreed. It was quite obvious.
That's what I'm saying. So are you saying that what he says and what the experts at trial said is the same, one and the same?
Well, yes. When it comes to this case, he and the experts at trial both agreed that there was an impact, an impact was necessary to create the injuries in this case. Yes, Your Honor.
I thought that there was correct me if I'm wrong, that there was some distinction or difference between the two doctors concerning the impact injuries. The Dr. Yashinsky said that you can have a skull fracture resulting from a low-distance fall or a short-distance fall. And what Dr. Newton, I think her name was, said that, yes, that's possible, that can happen, but that's not what happened in this case because there was swelling of the brain at the location where the skull fracture occurred, which is more consistent with a high-distance impact.
Well, Dr. Uzinski testified to two opinions at the motion for new trial. First, that a shortfall of 17.5 inches could cause the types of injuries that were suffered by the infant in this case. He then went further and said that that a comminuted skull fracture on the side of an infant's head could in fact be caused by a blow to the back of the head, leaving no marks on the back of the head. Here, not only was there a skull fracture on the frontal left parietal bone of the infant's head, but there was also an obvious contusion on the outside over that skull fracture, bleeding under the scalp located at the location of the skull fracture, as well as the subdural hemorrhage inside the skull, again at the location of the skull fracture, all on the side of the infant's head.
So let's take that. If Uzinski had testified at trial, he would have testified that a short fall of the type that Mr. Millien described from the sofa could have caused the injuries.
Well, I think that what he testified to was short of that. What he testified to was that a short fall of a distance of 17.5 inches could cause a skull fracture, could cause a subdural hematoma, could cause a retinal hemorrhage. He did not specifically opine to the actual injuries that were suffered by the infant in this case.
But he described the category of injuries which were consistent with the injuries suffered by this child.
The categories, and if the Commonwealth had merely presented evidence about the categories of injuries, if the Commonwealth testimony was only that she suffered a subdural hematoma, then maybe saying a subdural hematoma from that distance could be found to respond to that. But what the testimony actually was that there was extensive subdural bleeding, there was subgaleal bleeding, there was a contusion on the side of the head, there was a complex comminuted skull fracture extending in multiple directions from the left parietal bone, and there was serious cerebral edema, so that the infant's skull portion of it had to be removed for a significant period of time to allow the brain to swell without causing more.
And are you saying the prosecutor, when he was cross-examining Dr. Uzinski, didn't challenge him as to the extent of the injuries?
And Dr. Uzinski both failed to respond to, he never actually said that those injuries, either the extent of the injuries that were suffered or the combination of injuries that were suffered, could have been caused by the reported mechanism. Nor did he indicate that he had read the medical records, he had reviewed any of the ophthalmological records. So he was not actually even in a position, according to his testimony, to be able to opine to the nature, extent, and severity of the child's injuries.
And he didn't say, I'm reading now from the amicus briefs of the pediatricians, shaking was not scientifically plausible as a cause for the injuries, and that Johannes' findings indicated an impact injury. No.
He said that shaking alone was not a plausible basis for
So this is a misstatement of the testimony?
And I'm sorry, I don't have the quote
Okay.
in front of me.
All right, but
But-
you're saying shaking alone is actually.
Yes, that he alleged that there had to have been an impact, but in this case, everybody agreed that there was, in fact, an impact.
So he said there had to have been an impact.
Yes.
But he didn't also say it's not possible that it was. Are you tying them together? Because he didn't conclude the way you said he didn't conclude and tie them together?
No, I don't think he ever discounted that there could have also been shaking, but that his position was that shaking alone can't cause cerebral edema, subdural hemorrhage, and retinal hemorrhages, without there being cervical injuries or spinal injuries,
Neck
and
injuries.
possibly fractured ribs.
Did he testify that, did Dr. Oshinsky testify that the symptoms or the symptoms that resulted from whatever occurred could have occurred as a result only of a fall?
I don't think he did testify that they could have occurred only from a fall. His testimony was more limited in that he insisted that it could have been the result of an impact. His testimony about impact was also quite general. It was to the extent that any impact could cause any type of injury.
So all of these injuries could have been caused without any shaking,
That was
his testimony.
his position. He did not, however, testify that they were caused without shaking.
No, I understand that,
just
but he's basically saying that there were alternative explanations
to
for
the
all of the triad of symptoms, right?
To the extent that he addressed the actual injuries suffered by this infant, yes. He said that that any injury could be caused by an impact. He again did not testify to the extent or severity or precise nature of the injuries that were suffered by this infant.
So the question really is whether that testimony, such as he gave, would have been likely to make a difference to a jury who had only heard expert testimony consistent with the prosecution's theory of how these injuries happened.
And I think as
See alternatives to those.
Well, and I think as it was put by Justice Hines, that there was a clear gap between his testimony and that of the Commonwealth's case that was presented at
And
trial.
what was the gap?
That while he testified generally to types of injuries that could be caused by a shortfall, he did not testify that these injuries could have been caused
Is there
by a
any question
shortfall.
that these injuries didn't fall within those types?
Well, if we define them only as types, as opposed to explaining what the injuries were, what the observations of the treating physicians were, and the differential diagnoses that were conducted by the various physicians that saw the child. To the extent he opined that a skull fracture could be caused by a shortfall, I think the Commonwealth's witness agreed with that at trial. It could. A shortfall could cause a subdural hematoma, and a shortfall can cause retinal hemorrhages. But the instances in which those things could happen were explained as distinct from what was presented here.
I'm sorry, finish. I'm sorry.
So while those injuries could occur, these injuries, in the combination and to the extent that they were suffered by this infant, could not have occurred as a result of a shortfall. And Dr. Uzinski's testimony, quite frankly, did not address that.
In the amicus brief filed by the concerned physicians and scientists, they purport to have gotten some other records and looked at this and opined that all of this could have happened from a shortfall. And so I'm just wondering if that had been the testimony, you wouldn't be having, I'm just trying to see, is this because Dr. Uzinski didn't do this? That's where you're coming from.
Well, I think that we're to require that something constitute a substantial available defense, particularly in a case like this, where the reported mechanism of injury was quite clear. The defendant testified, the defendant gave multiple statements before trial to DCF, to the police, to neighbors, that this injury was caused by a 17.5-inch fall backwards onto the back of the infant's head. So he was limited to that reported mechanism of injury. So in this case, to provide a substantial available ground of defense, I think the least that should be required would be a qualified expert who is able and willing to opine that these injuries, the actual injuries, not just the types, could have been caused by that reported mechanism of injury. And that's not the situation we're in here.
So the credibility determination that the judge made concerning the two experts was really a determination that the defense expert at the motion for a new trial did not offer an opinion that was specific to the facts of this case, at least with respect to causation, with nexus between specific injuries and specific mechanisms for injury.
And I think it's more properly thought
Is that right?
as opposed to a credibility determination, that she determined that the scope of the defense expert's testimony did not respond to what the Commonwealth presented. I don't think it required or involved a credibility determination, just that it did not actually respond to that which was presented by the Commonwealth.
Can
So
I
it's,
take you back to something, because I want to make sure I got this right? Did your witness say, did Dr. Newton say that the triad was caused by shaking, but the other injuries had to be explained by other acts, like the impact?
no, there was no
Not say
distinction.
that. Okay.
It was not that there were two reported mechanisms of injury, that these injuries, she explained the forces or the reason that shaking causes the types of injuries that were seen here, but agreed or stated that obviously there was also an impact in this case. And that's consistent with the science that while shaking can create acceleration, deceleration forces that cause the type of forces that can damage an infant's brain and cause the types of injuries that are suffered here, those forces are increased whenever there's an impact with a hard or a soft surface. And that's what Dr. Uzinski's argument was, that without that impact, also with the shaking, that these injuries.
At the same time, not unconnected, like shaking and slamming,
I think that
not shaking, putting him on the stool and then falling.
not as two distinct events.
Correct. They have to
Correct.
be a continuous event.
Well-
Because the acceleration, she's trying to explain away the science that says you can't cause the brain to swing back that hard unless you break the child's neck, essentially. And so she says, well, yes, if you have an impact too. Isn't that what the
No,
Bronco
that
was?
in this case, that no one disputes there was an impact. I think the science is that, and I think the generally accepted view of the science is that the shaking alone can cause the types of injuries that are
I guess I
referred
meant
to
the
as the triad.
counter-science.
But that in any event, that when there's also an impact, then that can lead to greater forces, increasing the amount or extent or severity of the injuries, and that there's no question in this case there was an impact because of the signs of external trauma to the infant's head.
But is it the case that the prevailing science, and maybe this is wrong, is now that even though shaking alone can cause the triad, whatever, that it can be caused by other things as well?
Well, that was I think that the types of injuries that are suffered here can be caused by other things, and that's why the Commonwealth witnesses, not just the experts, but the treating physicians, testified in detail to the differential diagnosis that was conducted in this case, where they ruled out other potential causes of bleeding in the brain
But
or
surely the
neurological.
shaken baby syndrome, originally, the view was that this triad could only be caused by shaking. Is that no longer the view?
Well, I don't think, I'm not sure that there was ever that the relevant medical community ever said that it had to be caused by shaking alone. I think that part of ending in a result of determining that there was shaking involved necessarily involves conducting a differential diagnosis to rule out potential other causes of neurological difficulty or bleeding issues.
But can I just ask here, it's the Commonwealth's position and was at trial that these injuries could not have taken place without the shaking.
The Commonwealth's position,
There was impact, but impact alone would not have been enough. There had
Yes.
to have been shaking.
in this case, the
In
injury,
this
the
case, there
mechanism,
had to have been shaking.
the mechanism of injury was shaking combined with an impact.
Okay.
And that's particularly important in the context of the retinal hemorrhages. And the ophthalmologist who testified both at trial and at the motion for new trial explained in great detail how it's the shearing forces on the vitreous gel inside the eye pulling on the retina that caused the type of retinal hemorrhages that are found in this case, and how his differential diagnosis in this case ruled out other potential causes of these retinal hemorrhages.
And is there, I gather that there's no dispute that this occurred after Jeffrey left and before Jeffrey returned, that we have a moment in time?
Yes, there was
So
no
he's-
dispute.
he's watching a baseball game by himself, a Yankee playoff game, and during that time, and was there any description as to what the nature of the force would be? Would it be throwing the baby on the ground? What would it? was there any-
It would have been a high level of force. I don't think anyone gave specific examples for exactly what type of force it would have to be, but it was a very forceful, high impact.
And was there any evidence, as there was apparent in the other case, of any prior bad acts by Mr. Millien towards this child, apart from the fact that he thought she was whiny and not as easy as the twin?
No, apart from the fact that there were other injuries that were charged in the case that occurred at a prior date.
Was there any evidence of any physical force that he used against the infant apart from this?
No, there were no prior acts of prior physical or acts of
Were
violence.
the other injuries charged in this case? Oh, you
No.
mean all happening or allegedly happening simultaneously?
There were the vertebrae fractures
Oh.
and the head injuries that the defendant was found guilty, and then there were 2 charges for the tibial fracture and the rib fractures, of which the defendant was acquitted.
But did you offer any evidence of him doing anything to the child to cause those injuries?
No, not specifically. It was unknown exactly when the tibial fractures and the rib fractures occurred.
So the
They were
evidence
dated.
essentially was he did this and therefore
He must have
he
done that.
must have done that? That was basically the Commonwealth's theory of the tibia?
It was that the combination of injuries showed that somebody may have had ill will towards the child, and that they were associated injuries. But the jury considered the defense that was put on by the defense attorney, which was aimed in large part at showing that he was a loving, attentive father, and other people had custody of the child at the relevant time periods, and the defendant was found not guilty
You
of
actually
those
had no
offenses.
affirmative evidence whatsoever anyway, did you? On those other injuries?
The Commonwealth didn't know exactly when they had occurred.
Well, the doctor testified that they were in an advanced state of healing.
Yes, so they'd occurred, I believe the testimony was probably approximately 1 month earlier.
Did all the other caregivers testify at the trial?
I believe that they all did.
And they all testified, I'm assuming, that they didn't injure the child physically or
Yes,
deliver any impact to the child?
yes, they did.
All right, thank you.
So if there are no further questions, I will rest on my brief. Thank you.